Section 157, Annual General Meetings. 1. Except as provided in subsection 4, a company shall a. In each year hold a general meeting as the annual general meeting of the company in addition to any other meetings in that year. And b. Specify the meeting as the annual general meeting in the notice calling the meeting. 2. Not more than 15 months shall elapse between the date of one annual general meeting and the next. 3. If a company holds the first annual general meeting within 18 months of incorporation, the company is not required to hold the annual general meeting in the year of incorporation or in the following year. 4. The annual general meeting shall be held not earlier than 21 days after the financial statements, the consolidated financial statements, and the reports of the directors and auditors on the financial statements of the company have been dispatched to members and debenture holders of the company in accordance with Section 128, and the financial statements and reports shall be laid before the annual general meeting for consideration. 5. If the auditors of the company and the members of the company entitled to attend and vote at an annual general meeting agree in writing that an annual general meeting shall be dispensed with in any year, it shall not be necessary for that company to hold an annual general meeting that year. 6. If the annual general meeting is not held in accordance with subsection 5, the registrar may, on a motion by the registrar or on the application of an officer or a member of the company, call or direct the calling of an annual general meeting of the company, and may give the ancillary or consequential directions that the registrar thinks fit, including directions modifying or supplementing, in relation to the venue, calling, holding and conducting of that meeting, the operation of a. Section 159. b. Paragraphs 1 to 3 of the 8th schedule. c. Paragraphs 8, 9, 12, 13 of the 8th schedule. d. Paragraphs 15 to 19 of the 8th schedule, and e. The constitution of the company where applicable. 7. Where meeting held in pursuance of subsection 6 is not held in the year in which the default in holding the annual general meeting of the company occurred, the meeting so held shall be treated as the annual general meeting for that year, but shall not be treated as the annual general meeting for the year in which the meeting is held unless, at that meeting, the company resolves that it shall be so treated. 8. Where a company passes a resolution pursuant to subsection 5 or 7, a copy of the resolution shall, within 28 days of the passage of the resolution, be forwarded to the registrar for registration. 9. If an annual general meeting of the company is not held in a. accordance with subsection 1. b. compliance with the directions of the registrar under subsection 6. or c. compliance with subsection 4, 7 or 8 of this section, the company and every officer of the company that is in default is liable to pay to the registrar an administrative penalty of 150 penalty units. Section 158, Extraordinary General Meetings. 1. An extraordinary general meeting may be convened by the directors whenever the directors think fit. 2. If at any time there are not within the Republic sufficient directors capable of acting to form a quorum, a director may convene a meeting. 3. An extraordinary general meeting of a private company may be requisitioned in accordance with Section 299 and an extraordinary general meeting of a public company may be requisitioned in accordance with Section 324. Section 159, Place of Meetings. Unless the constitution of a company otherwise provides, the general meetings shall be held in the Republic. Section 160, Notice on Proxy. 1. In every case in which a member is entitled to appoint a proxy to attend and vote pursuant to paragraph 9 of the 8th schedule to this Act, instead of that member, the notice shall contain with reasonable prominence a statement that the member has the right to appoint a proxy to attend and vote instead of that member and that the proxy need not be a member of the company. 2. If there is a default in complying with this section in respect of a meeting, every officer of the company who is in default is liable to pay to the registrar an administrative penalty of 150 penalty units. Skip Section 161. Section 162, Power of Court to order meeting. 1. If for a good reason it is impracticable to call a meeting of a company in a manner in which meetings of that company may be called, or to conduct the meeting of the company in the manner prescribed by the constitution of the company, the court may, on the application of a director, a member of the company or the registrar, order a meeting of the company to be called, held and conducted in the manner that the court considers fit. 2. Where that order is made, the court may give any ancillary or consequential directions that the court considers expedient. 3. A meeting called, held and conducted in accordance with the order is, for the purpose of this act, a meeting of the company duly called, held and conducted. Section 163, Written Resolutions. 1. Except as provided in subsection 5, a resolution in writing signed by all the members for the time being entitled to attend and vote on the resolution at a general meeting, or being bodies corporate by the duly authorized representatives of the bodies corporate, is as valid and effective, for the purposes of this act as if the resolution had been passed at the general meeting of the company duly convened and held. 2. Subsection 1 applies where the company has only one member entitled to vote. 3. A resolution described as a special resolution is a special resolution within the meaning of this act. 4. A resolution is passed on the date on which the resolution was signed by the last member to sign, and where the resolution states a date as being the date of the signature by a member, that statement is sufficient evidence that the resolution was signed by that member on that date. 5. Subsections 1 and 4 do not apply to a resolution to remove an auditor, which can be passed only at a general meeting in accordance with Section 141, or to remove a director, which can be passed only at a general meeting in accordance with Section 176. Skip sections 164 and 165. Section 166, Minute of General Meetings. 1. A company shall cause minutes of the proceedings of general meetings and meetings of a class of members to be entered in a book or books kept for the purpose. 2. A minute under subsection 1, if purporting to be signed by the chairperson of the meeting at which the proceedings took place or of the next succeeding meeting, is sufficient evidence of the proceedings. 3. Where minutes have been made in accordance with this section, until the contrary is proven, the meeting shall be deemed to be duly held, convened and conducted. 4. Where a company fails to comply with subsection 1, the company and each officer of the company that is in default is liable to pay to the registrar an administrative penalty of 250 penalty units. Section 167, Inspection of Minutes Books. 1. The books containing the minutes of proceedings of a general meeting or class meetings of a company shall be kept at the registered office of the company and shall, during business hours, subject to reasonable restrictions that the constitution of a company may impose, be open to the inspection of a member without charge. 2. Not less than 2 hours in each day other than a Saturday or a Sunday or a public holiday shall be allowed for inspection under subsection 1. 3. A member is entitled to be furnished at a cost determined by the company, within 10 days after the member has made a request in that behalf to the company, with a copy of the minutes. Skip sections 168 and 169.